If your clinic is using AI tools to record patient consultations, and a lot of clinics are in 2026, I need you to stop and ask yourself one question before your next appointment. Do you actually know where that recording goes? Because right now, in 2026, that question is already in a courtroom. Patients are filing lawsuits claiming their medical conversations were recorded without their knowledge, transmitted to third-party vendors, and stored in ways they never agreed to. And the clinics being named in these cases are not rogue operations. They are legitimate healthcare providers who turned on a technology tool without building the compliance infrastructure around it first. If you are using AI, ambient scribe in your med spa, and you have not reviewed your consent protocols, your vendor agreement, and your state's recording laws, this video is for you. In November of 2025, a class action lawsuit was filed against Sharp Healthcare in San Diego. A patient discovered that this routine physical exam had been recorded using AI scribe tool without his knowledge. When he checked the patient portal afterward, the recording said he had been advised and had consented. The lawsuit calls that language false. The case is now potentially open to every California patient seen at Sharp facility after April of 2025, and compliance and legal experts across the country are pointing to this as the first of many. Now here is what surprises most clinic owners when I bring this up. They say, we are HIPAA compliant. We have our policies in place. We are covered. But what compliance professionals are currently flagging is that HIPAA alone does not cover everything that is happening when an AI tool enters the room. There are state recording laws, biometric data, and vendor contract issues that HIPAA was never designed to address. And that gap is exactly where the exposure lives. Today, we are going to cover three things. First, what the Sharp Healthcare lawsuit actually tells us about how these tools are being deployed right now. Second, the specific compliance gaps that turn a useful AI tool into a liability. And there are more than one. And third, and this is the part most clinic owners never heard about, what a compliant AI scribe setup actually looks like before you turn on the microphone. Stay with me, because that third piece is what separates clinics that can defend their practices from the ones that cannot. Let me start with what is actually being reported, because this is the case compliance professionals are watching right now. Sharp Healthcare deployed an AI ambient scribe in April of 2025. The tool was installed on clinician devices and automatically record patient encounters to generate draft clinical notes. In July of 2025, a patient named Saucedo went in for a routine physical at a Sharp Healthcare clinic in San Diego. According to the lawsuit, he was not informed that this visit was being recorded. He was not asked to consent. The audio of his private medical conversation was captured, transmitted to a third-party vendor's cloud system, and used to generate clinical notes, all without his knowledge. When Saucedo later checked his patient portal, he found documentation indicating that he had been advised about the recording and that he had consented. The lawsuit calls that language false. The case was filed in November of 2025 as a class action lawsuit under California's strict wiretapping law, the California Invasion of Privacy Act, and the Confidentiality of Medical Information Act. If it is certified as class action, it could include every California patient seen at that Sharp Healthcare facility after April of 2025. The potential damage under CIPA alone can reach $5,000 per violation per recording. But California is not the only state moving on this. In September of 2024, Texas reached a first of its kind healthcare AI settlement against a company called Pieces Technology, imposing 5-year compliance obligations and signaling that state regulators are not waiting for federal guidance before they start enforcing. These are not edge cases. They are the beginning of a pattern that compliance professionals say is coming to every state. But here is what those cases actually reveal. And it is not what most clinic owners expect. The problem is not the AI tool itself. The problem is what is missing before anyone turned it on. When compliance professionals review how these AI scribe tools are actually being deployed in med spas and aesthetic clinic settings, the same gaps show up consistently. The first gap is the vendor agreement. When you sign up for an AI scribe tool, you are likely handing a third-party access to protected health information. Under HIPAA, that vendor is what is called a business associate, and you are generally required to have a signed business associate agreement with them before any patient data is processed. That agreement needs to specifically address how the vendor handles your patient's data, whether they use it to train their AI models, and what happens to the data when you stop using their services. Most clinics that compliance professionals are reviewing right now either do not have this agreement at all or have a generic one that does not address any of those specifics. The second gap is patient consent, and this is where the sharp case lives. Most state recording laws require that patients be informed that a recording is taking place. Some states require all parties to actively consent. If your clinic is using an AI scribe and you do not have clear, documented, visit-level consent workflow, meaning the provider tells the patient at the start of every appointment that a recording tool is being used and gives them the option to decline, you are relying on a process that courts are now examining very closely. California AB 3030, which took effect January 1st of 2025, requires healthcare providers using generative AI to include specific disclosures in patient communications. Utah and Colorado have their own AI disclosure requirements, and compliance experts are pointing out that more states are following. The third gap is one that most people have never heard of. In February of 2025, a federal court in California established what is being called the capability test in a case called Ambrizz versus Google. The court held that an AI vendor does not have to actually use your patient data to create liability. If the vendor's tool has the technical capability to use that data for things like training their AI model, that alone can be enough to trigger legal exposure, which means the question is no longer just whether your vendor is using your data. The question is whether their tool could. This is a knowledge gap problem. Most clinic owners turning on these tools are not making reckless decisions. They are adopting technology that generally improves their workflow, but they are doing it without the compliance infrastructure that the law and now the courts are requiring to be in place first. Now you might be thinking, okay, I need to review my vendor agreement and update any consent forms. And yes, you do. But here's where most clinic owners stop short, because there are two more things that need to be in place before this setup is actually defensible, and most of the audience out there never mentions them. When compliance professionals describe what a properly set up AI scribe situation generally looks like, it comes down to four things. 1, a HIPAA-compliant business associate agreement with the vendor. Not a generic terms of service click-through, an actual signed agreement that specifically addresses data handling, model training restrictions, subcontractor access, and data deletion when the relationship ends. If your vendors will not sign one of these, that is your answer about whether to use their tool or not. Second, a documented visit level consent protocol, not a checklist buried in a new patient intake paperwork. A workflow where the provider verbally informs the patient at the start of every appointment that an AI tool is recording the session and that the patient can opt out. And that consent or that declination gets documented in the record every time. Third, a state recording law review. Before you turn on any recording tool, someone needs to confirm what your specific state requires. One-party consent states and all-party consent states have very different standards, and the penalties for getting it wrong vary significantly. This is not a one-time check either. As states continue passing AI disclosure laws, this needs to be reviewed regularly. Fourth, a HIPAA security risk assessment that includes the AI tool. When you bring a new technology into your practice that handles patient data, that tool needs to be formally assessed as a part of your security risk management process. Not because it's bureaucratic, because if a complaint or an investigation ever opened, that assessment is part of what demonstrates you took responsible steps to protect the patient data. Knowing what it should look like and actually having it in place and documented before your next patient appointment. Those are two different things. And that is where most clinics are still exposed right now, even when they think they are covered. Here is what needs to happen and what needs to be documented before you turn on the microphone. Start with your vendor. Pull the agreement you signed with your AI scribe company and read the data section carefully. Look for the language about model training, data retention, and third-party subcontractors. If you cannot find a signed business associate agreement in that documentation, reach out to that vendor before your next appointment. From there, build your consent workflow. It does not have to be complicated. At the start of every appointment where the AI tool is running, the provider says something like, "I am using an AI tool that records our conversation to help me document your visit accurately. You can opt out at any time. Please just let me know." That conversation gets noted in the record every time. Next, have someone review your state's recording consent requirements. This is where connecting with a compliance professional or healthcare attorney is genuinely worth it, because the answer varies by state and it changes as new laws pass. Finally, update your security risk assessment to include the AI tool. Document that you reviewed the vendor's data practices, that you have a BAA in place, and that your consent protocol is active. That documentation is your protection if a question ever comes up. Most clinics are not doing all four of these things, not because they are careless, but because no one laid it out clearly before they started using the tool. These clinics that are building this infrastructure now are the ones that will not be scrambling later when a patient asks how their data was handled. I told you at the start that the question every clinic owner needs to ask is whether they actually know where their AI recording goes. We just walked through exactly what that answer needs to look like: the vendor agreement, the consent workflow, the state law review, and the security risk assessment. And if you went through that list and realized you are missing one or more of the pieces, you're not alone. That is the reality in most of the clinics compliance professionals are currently working with. The technology moved faster than the guidance, and a lot of good clinic owners are in the gap they didn't know existed. Here is the truth about AI and compliance in med spas right now. The AI did not violate HIPAA. The missing paperwork did. The tool recording that consultation is not the problem. The problem is turning the microphone on without the documentation that the law requires to surround it. Compliance is not about whether your technology is good, it's about whether your systems are built to protect your patients and your practice when someone asks the hard questions. If you want help reviewing your AI tool setup and making sure your consent protocols and vendor agreements are built correctly, this is exactly the kind of work we do at ACE. Click the link below. The AI tool did not violate HIPAA. The missing paperwork did. If this one hit close to home, the next video is about your social media, and the FTC is now using AI to scan your posts for compliance violations. If you are making claims about your treatments online, that one is for you, and it's up next.